Good morning. I'm Linda Modlinski with the Minnesota Association of Realtors, and the topic of my discussion today are listing agreements, who owns the agreement, and what happens to the listing when an agent decides to make a move to a different company. I'm sure we all would agree that a salesperson is doing business on behalf of a company and the brokerage that he is licensed to. So when a agent takes a listing, that listing belongs to the company. If the listing agent makes a decision to transfer to a new company, the listing stays with the company. The only exception to this would be if the listing agent and the broker signed an independent contract agreement, and there was a clause in that agreement that allowed a transferring agent to take any and all listings with him to his new company. Absent such an agreement and a clause, the listings belong to the listing company. And an agent, when they made a decision to transfer to a new company, is limited and cannot have any conversation with their clients that would be construed as an inducement to breach their listing contract. That means that the transferring agent can't have any conversation that would encourage the seller to cancel that contract and then relist with the agent at their new company. Oftentimes when we have this conversation, agents will tell me, I don't live in the real world. They tell me that the only reason that the seller listed with the company was because of that particular agent. And that may very well be the case, but it still doesn't give that listing agent the right to have a conversation with the seller that would induce them to breach their current contract. Engaging in such a conversation, either prior to leaving the company or after they have left the company, would be viewed as an inducement or a breach of contract. Not only would this be a violation under Article 16 of the Code of Realtors, and it's defined under Standard of Practice 16-20, it would also be a violation of agency law, and it could trigger complaints to be filed and actions taken both by the Minnesota Association of Realtors and the Minnesota Department of Commerce. An agent who is leaving a company can certainly announce to his clients that he has made a decision to go to a different brokerage. If the seller asks the agent what's going to become of the listing agent must explain that that listing remains with the company, and any further discussions needs to be with the broker or the manager of that company. Some agents have indicated that they have made a decision to leave the company and they have left without even having any contact with their sellers. They have asked whether or not they can contact their former sellers now when they're with their new company and explain that they have left. And the answer to that is no. All agents, even recently transferred agents, must respect the established agency relationship, and they can have no former contact or conversations with their former clients. Whether an agent agrees with these restrictions that are placed upon them or not, they are duty bound both under the Code of Ethics and under the Minnesota Department of Commerce license law to refrain from having any conversations relating to a breach of a current listing contract. We hope you found this information to be helpful, and here's wishing you a good day and a great week in real estate.